So this work took place a few months ago and it's driven by Anjali and I, but I also want to thank Renuka and Chitrakshi from TrustBridge along with other people from the office, and particularly Nimal, who is a student at NLUD who helped us with reading the judgments, which forms part of this study. And so one of the reasons for the work was that at this point, the failure of arbitration has sort of permeated into pop culture that there are now jokes about it. And the fact that you end up litigating arbitration is not sort of missed by anyone anymore, right? And just to quickly go through how that failure might come up, if you have an arbitration agreement, again, there are some assumptions in this flowchart that your dispute is over 2 crores and in Delhi because of the jurisdiction of the High Court. Instead of working with those assumptions, all that an arbitration agreement is really doing is adding that first step of arbitration. And then you have 2 steps of litigation in the Delhi High Court before you go in an SLP, the Supreme Court. So the arbitration agreement really isn't doing anything other than adding one more stage of dispute resolution. And that's sort of also what we believe that common perception might be on this issue. What that leads one to think about is the fact that there has been plenty of work on the first stage of court-driven dispute resolution in arbitration. I'm just going to repeat that again. That there are 2 steps of court-driven dispute resolution in arbitration. The first is at the High Court, and the second is at the Supreme Court. There is plenty of work happening and has happened on the first level, which is dispute resolution regarding an arbitration agreement in a High Court. Some of this work has been done by TrustBridge, some by KDR, and the rest by others. But we think that there is a lack of work or perhaps an opportunity to do more work on that second level of dispute resolution. That if you have a dispute, if you have an arbitration agreement, you first litigate that agreement as well as the award that comes out of that agreement at the High Court. But you also have an opportunity to litigate it at the Supreme Court under the court's 136 jurisdiction. And there is some literature to suggest how this jurisdiction itself has been expanded over the years. For example, the court, and as we will see in this presentation itself, the court has expanded how it can think about or question arbitration and has given sort of vague ideas which really increase litigation. We're not drawing that causal link at the moment. But there are opportunities for the Supreme Court to step into this process, and that's why it may be important to sort of understand what the Supreme Court does in this process. Okay, and this is important because the Arbitration Act, as it is now called, came into place about 30 years ago. And it's been amended frequently and often. The last notified amendment happening in 2015. That's substantive. There's a 2019 amendment as well, right? So we sort of wanted to ask a few questions and understand what is happening at the Supreme Court, what kind of questions are coming up, and then what is the court doing in that regard. And this is important so that we can add a level of certainty and consistency in dispute resolution, because at the end of the day, an arbitration is just a part of a contract between 2 parties, and they've decided to resolve that dispute. And so this is a choice that the parties made, and we want to follow that journey through to its end and see how that dispute resolution is really taking place. Okay, and we ask largely 4 questions, and I will come to how we attempt to answer them. One is, what type of arbitration-related matters are reaching the Supreme Court of India? This is significant because there is going to be a selection happening or a filtering happening through the multiple stages of litigation. Right? Does the Supreme Court create certain incentives for parties by its approach? What is the life cycle of these disputes? You had an arbitration, as I said, you will have 2 stages of High Court litigation, at least in Delhi, and then you will have as we will see later, multiple stages of Supreme Court litigation. So how long is this dispute resolution taking? And is any of this attributable to party types, which is some of the work we've seen in other litigation, both at the High Court and at the Supreme Court level? And we want to question whether arbitration has similar patterns. Okay. The way we tried to address this was to look at significant judgments, and I will come to how we define them in a second. The reason to do this is because this allows us to understand what the Supreme Court is doing in arbitral awards 1 and arbitral proceedings 2. And second, because both the Supreme Court itself as well as the High Courts take cue from what the Supreme Court does in certain cases. The court is both the Supreme Court and the High Courts are courts of precedent, and so it is likely, as well as established in other work, that how the Supreme Court really sets the path of the law, or at least it can under its 142 jurisdictions. We wanted to look at selective cases and see what broad strokes the Supreme Court's drawing, right? So we looked at significant justice. We defined this in 4 ways. These are all and options. They're not or options. So we looked at decisions between 2015 to 2023, which is the period of certainty of the Arbitration Act. Here, I only mean certainty in terms of non-amendment of the Act. So at least the language of the Act has been relatively stable over the period of these 8 years, now 9. So in this 8 years, we look at the top 10% of most cited cases, the top 10% of most cited cases per year. This helps us address the bias that if there's a significant judgment that happened in 2023 itself, it might have lower citation counts, but is it comparable per year to previous judgments? Cases with 5 or more judges, and the Supreme Court has the ability to define something as a landmark judgment in its own annual reports. And we see whether the Supreme Court defined any arbitration matter as a landmark judgment in these 8 years. We used Manupatra for this, which gave us an arbitration toggle on Manupatra, gave us a universe of 347 cases, out of which we identified 33 as significant. Right? And then there was a reading exercise of those. Just quick summary statistics. There's a range of citation counts going up to over 300 citations, which means over 300 judgments have relied on 2 of our judgments. And the average also, while it's not apparent here, I remember to be around 120 or 120 to 125, if I remember correctly. And then the number of judges, there's a wide range of strength at the Supreme Court. This is fairly obvious why that might be the case. 5 and 7 judgments are specially assembled by the Chief Justice, and 2 and 3 are default depending on who the judge at the Supreme Court hearing the matter is. So this is largely in compliance with what you would expect to see. Okay, and we see 3 problems happening at the Supreme Court in arbitration disputes. The first is repeated litigation. So repeated litigation on a section can create uncertainties. This is again self-evident on why this might be a case. The Supreme Court of India, unlike the Supreme Court of the United States as well as that of the UK, does not sit en banc and has the ability to give varying opinions on similar matters and set precedent across judges and ideologies, right? And what we see is that of the 33 cases, 4 sections were repeatedly litigated. These are Section 8, 11, 34, and 37 of the Arbitration Act. We have the count within our 33. And we also have the number of cases which have cited these cases themselves, right? Which means over 1,000 times are the same disputes of 8, 11, 34, 30 coming up to the High Court and the Supreme Court, because that's also the data set of Manupatra. So citations are restricted to High Court and Supreme Court, right? This is just absurd. The fact that you're litigating the same provisions again and again and trying to figure out an answer on how to interpret them is bound to set sort of answer to cement uncertainty within these provisions. We will see a few examples of that happening. Quickly, for those of us who might not remember the sections immediately, Section 8 is for the existence of arbitration agreements. Section 11 is for interim awards by a court till an arbitral tribunal is formed. Section 34 and 37 are challenge to arbitration awards. 34 is direct challenge. 37 is a challenge to a 37 decision. Okay. And what I'll do is that I'll go through the 3 problems we find quickly by 2 examples within our sample. There are many more of these, and I'll be happy to discuss them. I've restricted them at the moment for time. Right? I just want you in A. Ayyaswamy versus Parasivam to look at the last line. The last 2 lines, right? That there's a difference in complex fraud and simple fraud. Complex fraud cannot be arbitrated. Simple fraud can be arbitrated. The fraud in this case was not complex, and it could have been arbitrated. The High Court had earlier held otherwise. Yeah. Just 2 years down the line, the Supreme Court is again faced with this question on what type of fraud is arbitrable. Again, I just want you to look at the last sentence. Allegations of fraud in commercial disputes do not preclude arbitration. That means in commercial disputes, there is no test of whether it is simple or complex. Commercial disputes should whatever type of fraud happens in a commercial dispute is possible to be arbitrated, but we don't know what a commercial dispute is, how a court is supposed to understand whether a dispute is commercial versus not. We've seen similar problems in the Supreme Court's, both the Supreme Court and the High Court's understanding of commercial disputes in interest to be awarded in disputes, because the civil procedure code says different interest has to be awarded on whether it's a commercial case versus not. And there's a wide range of things happening there, right? For example, if the state is building a bridge, that is not a commercial dispute, even though there might be a dispute between the state and a contractor. So there is no understanding what a commercial dispute is. They can be arbitrated, others cannot be arbitrated. There is no clarification on what is simple fraud versus what is complex fraud. All courts are supposed to understand that themselves. And these are filtered down. We have 33 judgments at the end of the day of the Supreme Court. These are supposed to be very selective. The fact that multiple times the question of whether fraud can be litigated finds itself within this small sample of 33. This tells you how frequently these things come up to the Supreme Court, and how there is no certainty on there is no finality on how these things have been decided. Right? And again, I'm not going into them, but we have the same problems happening with 1134 and 37. Okay. Then there's a problem of cycle of appeals coming up to the Supreme Court. Now, not all appeals are bad. There is a body of literature that suggests the usefulness of appeals, but there's also the possibility of repeated litigation happening if too many appeals take place. This has to be sort of understood in light of the fact that we've already seen that it's the same provisions coming up again and again. So not only do you have the same type of disputes, you're just going through a cycle of litigation with them. And as you will see, this also creates a scenario where all of these are taking too long to reach finality. Okay. What is happening at the Supreme Court? Right? What comes of this cycle of appeals? Nothing comes of this cycle of appeals, except for the fact that the Supreme Court doesn't agree with high courts in this country, which might be a separate sort of line of investigation in itself. What we see is in our 33 judgments, 9 were not coming from an impugned high court judgment. The reason for this is that if a Supreme Court establishes a special bench, which might be a 5 or a 7 judge bench, those don't have an underlying judgment. That's the Supreme Court now effective, at least for its own understanding, taking up a new matter. So that leaves us only with 26 impugned judgments. Out of 26 judgments, 17 judgments by the Supreme Court were overruled. The court did not agree with the judgment of the High Court. Right? So what is happening? The reason you're coming up multiple times is because it is possible that the Supreme Court will, not only is it possible, it is likely that the Supreme Court will overturn the judgment of the High Court, right? And this creates an incentive for you to keep coming to the Supreme Court, because they have multiple tests for the same question, and they likely not agree with the High Court in the matter. Right? And we have sort of ideal cases for this. I won't go through the DMRC case again, because many of us on this call are already well aware of it. But look at the repeated litigation that happens, right? There's first an arbitration award, then there's 2 cycles of litigation at the High Court. And for the purpose of the study, there's 1 cycle at the Supreme Court, because we stop at 2023. But we know now that there are 3 cycles of litigation in the Supreme Court. There's 6 levels of dispute resolution happening, only to come to the conclusion that the High Court was, well, in this case, right, but the original 21 judgment says that the High Court was not right. So not only did the Supreme Court, after 4 cycles of litigation, the Supreme Court decide that the High Court was wrong in its final conclusion. In fact, the Supreme Court itself was later overturned by the Supreme Court itself. Right? And this happens in sort of smaller cases as well. In UHL versus Himachal Pradesh, the question is really of compound interest, whether the arbitrator could award compound interest or not. The arbitrator does so, and the High Court, through 2 cycles of litigation, first finds no interest could have been awarded. Later says, okay, simple interest could have been awarded. Supreme Court says, no, the High Court read our judgment wrong, because we had earlier said that only simple interest could be awarded. But we have overturned our previous judgment. And so the High Court didn't know the latest law on this question. And we now have to overturn the High Court because of its ignorance on the correct law. And in fact, compound interest is awardable. Look at the level of this question on whether in a dispute, an agreement which already posited compound interest. You've done 4 rounds of litigation with the Supreme Court to overturn a High Court only on the ground of the fact that we have too many judgments on this. So the High Court didn't know what the latest law on this question. And this sort of leads us to, of course, the timeline question, which all of us have pondered within the fact. I won't go through on why these things are important to measure. And of course, it's important to sort of caveat that we only look at 33 judgments. These are, by definition, judgments that may take longer than other. Right? But look at what's happening just at the Supreme Court itself. Right? It's taking well over a year for the Supreme Court, it's for the Supreme Court to decide the matter. In these 33 judgments, it took 4 years for the arbitration to finalize. Then it took about a year and a half for that matter to reach the Supreme Court. Then it took about a year and a half for the Supreme Court to come to a conclusion. These are not small numbers, right? And if you divide this down by the sections, you will see that the Supreme Court itself took 937 days in case of 34 matters and over 1,000 days in case of 37 matters to decide. Again, look at the cycle of litigation here. Right? There's an arbitration, there's a 34 first happening at the High Court. There will likely be a 37 happening at the High Court again. Then you've come to the Supreme Court, and then the Supreme Court has taken over close to 3 years to decide your matter. The arbitration was the promise of arbitration was supposed to be that this will be quick dispute resolution, right? And you're taking, if you just add up these numbers, which I understand you can't in terms of medians, but just to get some priors, you're taking 7-8 years for final dispute resolution. For those of us who have seen these numbers in civil courts, it might be important to sort of later analyze whether the period in arbitration is taking longer than civil disputes. My sense actually is that it is. Civil litigation is shorter, if not taking the same period of those in arbitration. Right? Again, I'll run through some quick examples. Again, in Dampel versus DMRC, we know that it takes about 5 years between 23rd October 2012 to 11th May 2017 for the arbitrator to come to a conclusion. And 2017 to now 2023 of the latest decision, it takes 6 years for that dispute to move out of arbitration and go through the court system to reach its conclusion. Again, to go back to the question of what we saw of compound versus simple interest, it takes from 2005 to 2022, takes 17 years for this question to finally be decided by multiple forums at courts, right? So it's just absurd that it's taking 17 years for you to decide whether the arbitration award should carry simple interest or compound interest or no interest at all, right? This is the only question happening at all these stages of litigations. We sort of try to understand whether any of these three problems are explainable by party types. Again, for the benefit of time, I'll just quickly say no. When you divide all of them by private party versus state parties, the proportions largely remain constant. I'm happy to come back to these slides if anyone wants. But again, on repeated litigation of sections, similar proportions, on matters being overturned, similar proportions, as well as in time taking similar numbers, right? So private parties are just as likely to litigate the same provisions, have the decision of the High Court overturned, and take the same amount of time at the Supreme Court as state parties. Now, why do this exercise, right? And what did we find out? We see that it's the same provisions being litigated again and again, without a sense of certainty and finality, because no matter what the High Court decides, it is quite likely that the Supreme Court will overturn that and set standards and tests that are not easy to interpret and apply. And these are borne out in case studies of High Courts finding it difficult to understand what the law on the matter is. And all of this is just taking as long, if not longer, than civil disputes are. And so I think the purpose, the conclusion of the study is to really question the efficacy of arbitration in ADR, and to question when and where should we think more deeply about when and where to apply both of these, whether arbitration or another form of ADR. We know that the Ministry of Finance has an OM recently, I would say about 4 months, which itself criticizes arbitration in state disputes. And can any of this really be fixed? I think the larger question this raises, can any of this be fixed by fixing arbitration? Or is this a problem of fixing courts? Because it's likely that both arbitration and ADR function in the shadow of courts until the time you fix this behemoth, which is the court system. Can we really hope of getting nice arbitration outcomes, if any? Thank you. I'll stop there, and I think there's some comments.